everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I want to discuss with you and remind you about why estate planning is important. Now, we all know with the coronavirus going on, and it's been all over the news, and it goes through ups and downs with the number of people who are infected, and for some people it can turn into a serious illness if it's contracted. Now, thankfully, for the great majority of people who have contracted the disease, the symptoms appear to be relatively mild. Nevertheless, it's crucial for everyone, particularly those who are in good health, to continue to take all the steps necessary to protect those around us who are more vulnerable to becoming seriously ill if they're exposed to the coronavirus. Although most people are not likely to be in serious danger, even if they come down with the virus, it is a wake-up call to those who have been putting off creating or updating an estate plan. None of us knows what tomorrow will bring. So for your own peace of mind and the good of your loved ones, it's important to stop procrastinating. Now, there are several key documents an estate plan should include to protect you and your family if you should suddenly become very ill or pass away. These key estate planning documents consist of a will, a trust, powers of attorney for both medical and financial, advanced directives or a living will, and we also talk about funeral planning. So let's talk about the last will and testament first. A will enables you to specify the individuals you would like to receive your money and property. In addition, you can name a guardian to care for your children or other dependents if you are unable to do so, and a conservator to handle their financial needs. For many, however, a will alone is not the best solution, as it's only effective after you pass away. So let's talk about a trust. You see, in a revocable living trust, you can name yourself as trustee or the manager of the trust and continue to exercise control over the money and property that you put into the name of the trust. However, it also enables you to name a co-trustee or a successor trustee, someone who can manage your money and property for your benefit or the benefit of any other beneficiary of the trust if you become incapacitated and you're unable to do it for yourself. In addition, the trust can specify when and how the funds should be distributed to your beneficiaries when you pass away. Furthermore, if you have transferred all of your property into the name of your trust, it will not have to go through the probate process, which can be expensive, time-consuming, and open to the public for anyone to be able to see what it is that you had and to whom you're passing it on to. If you do not create a will or trust specifying who you would like to receive your money and property when you die, it will pass to the individual specified under the state intestacy statute, and they'll receive the inheritance. Obviously, this is not optimal for you, as the people in the shares spelled out in the statute may be vastly different from what you would have specified in your own estate plan. Moreover, probate is required for the administration of your estate if you die without a will or a trust. In addition, a court will have to appoint a guardian and/or a conservator to care for your children, and the person appointed may not be the individual that you would have chosen. Using a power of attorney, you can name people you trust to make decisions on your behalf if you become ill and you're unable to make them for yourself. Even if you are married, your spouse may not have the authority to make all of these types of decisions for you without the proper documentation. Now, a healthcare power of attorney or medical power of attorney can be used to name a trusted person as your agent to make medical decisions on your behalf if you're unconscious or otherwise unable to communicate them to your healthcare provider. As your agent, the person you have named is required to act in accordance with your wishes to the extent that they are known to that individual. So it's important to communicate important information regarding your preferred providers, your medical conditions, treatments that you do not want, religious convictions, and other important information. A durable financial power of attorney will allow the person you have named as your agent to make financial decisions and conduct business on your behalf if you cannot handle these matters for yourself. It can be as broad or as limited as you choose. For example, you could authorize a trusted individual to run your business for you, or you could simply authorize another person to write checks and pay your bills on your behalf. So what happens if you do not have these powers of attorney in place? If you do not name trusted individuals to act for you in medical and financial powers of attorney, your family members, including your spouse under some circumstances, will have to go to court to be appointed to this role. As in the situation in which you do not have a will or a trust, you no longer have any control over who is named to act on your behalf. The person appointed by the court may not be the person you would have wanted to take on these important roles. Your advance directive, also known as a living will, is a document that clearly spells out your wishes for the end of your life. For example, whether or not you want to be placed on life support, if you're in a vegetative state, or if you have a terminal condition. This important document allows your family and healthcare providers to understand your wishes, even if you are no longer able to communicate them. Now let's talk about funeral planning. You can use the Memorial and Services Memorandum to provide information to your family and loved ones about your wishes for your service, people who should be notified when you pass away, instructions regarding your remains, and information you would like to have included in your obituary. If you do not provide this information in advance, your grieving family will be left to guess about what you would have wanted after you passed away. This could lead to unnecessary stress and conflict at a time when they are likely to be feeling emotionally overwhelmed. Certain situations can bring our own mortality to the forefront of our minds, even if they are unlikely to have a severe or a direct effect on us. The coronavirus has still only affected a limited number of people in the United States so far, but it provides an important reminder of just how important it is not only to us, but also to our family members and loved ones to have an estate plan in place in case the unexpected happens. Our foremost goal is to help you have confidence that if you become ill, your own care and the needs of your family will be addressed. Call us today to set up a meeting, which can occur virtually if you prefer. Thank you for watching. I'm Kelly Longtin from Kelly Longtin Law.